In this video, we'll discuss Texas probate with a will. We'll cover the different options available to you, depending on the circumstances of the estate. Probate is the legal process of administering a deceased person's estate. When there is a will, the process is generally more straightforward. One of the first things we need to determine is whether the estate has any debts. This will impact the probate process. If there is a properly drafted will, and the estate has no debts, other than secured debts such as mortgages on real estate or car loans, you may not need an executor. So you can do a muniment of title. The judge will simply order that the will is valid and we must do what it says. With this, you do not need an executor. We file it with the deed records to move the house to the new owner, and use it at the DMV to move cars and bank accounts. If there is a properly drafted will and says that there is to be an independent administration and no bond, then the estate may qualify for independent administration, which means that we do not need to go back to court and get the judge's approval for everything. We are independent of the judge. This is the most common probate procedure. Independent administration can be less expensive and time-consuming than dependent administration. It also allows the executor to have more control over the administration of the estate. If the will does not allow for independent administration, we must use a process called dependent administration. Dependent administration requires the executor to obtain court approval for many actions, such as selling assets and distributing property to the beneficiaries. The process of dependent administration can be more time-consuming and expensive than independent administration. Probate can be a complex process, and it's important to seek legal advice to ensure that it's handled properly. An attorney can help you determine the best course of action for your specific situation. Call us at 214-843-1751 or go to our webpage at jacschuster.com.